Hello. I want to introduce myself. I'm Jennifer McGlone. I'm the Chief Legal Officer of Court Buddy. I wanted to welcome you all to our first virtual legal meetup. We're really excited about this today. We hope it's of real service and use to people. We're so happy that so many of you signed up to attend. I want to tell you a little bit about Court Buddy and why we're conducting this meetup and what we're hoping to accomplish today. I want to introduce you to my esteemed panelists, my colleagues. They're all experts in their respective fields. They are donating their time today to try to be of service to you and to try to help answer your questions. And I really appreciate them. And then I also want to tell you a little bit about how we're going to conduct the meetup. We're all getting used to Zoom technology, so bear with us. I think it's going to go smoothly. Bear with us if it doesn't. Let me tell you what we're going to do. So first, a little bit about Court Buddy. What Court Buddy is we are a company that matches individuals, families, and small business owners with attorneys. We stay with them throughout the entire relationship, be that just for one piece of legal service or an entire case. We help the attorneys and clients connect virtually and remotely, which is very important right now. And we also make working with attorneys easy, understandable, and affordable. So if you do need an attorney, courtbuddy.com, we're a great resource for that. But what we're doing today is we're trying to respond in real time to the circumstances that we're all up against and that are unfolding around us. At Court Buddy in the last few months since the COVID-19 pandemic started, we've seen a huge spike in traffic to Court Buddy. We've seen lots more people call into our helplines. We've seen people visiting our sites in unprecedented numbers. We've seen people coming to our live chat. And usually, historically, what people do when they come to us is they ask us, can you find me a good lawyer and what's it going to cost? And we are still getting those questions, but we're getting a lot of other questions as well right now. We're getting questions like, how do I file for unemployment? Do I pay my rent? If I've been unemployed, should I be living on my credit cards? Can I see my kids? I don't have custody. Can I see them during the coronavirus? We're getting those kinds of questions. And because so many people are struggling financially, many of them are hesitant to put money down to talk to an attorney. So with that in mind, we want to be of help and we want to be of service. And we've recruited these great attorneys that you're looking at all around me. And they have agreed to try to give you some practical and pragmatic answers to your questions. Here's how it's going to go. Here's how it's working. We have more than 200 people right now on this Zoom call. We had well more than 200 people sign up, and we've gotten almost that many questions in, because when you signed up, you were allowed to type in your question. I'm going to do my very best in the next 2 hours to get through as many questions as possible. I don't know that we're going to get to everyone's questions. So what I've done is I've taken all the questions, I have categorized them into different topics, and I'm going to start with the questions that more than one person asked, or the questions where I think the answers are going to be beneficial to a lot of people. We're going to hop around, we're going to cover all the topics, we're going to talk to all the attorneys, but we're going to start with those broader questions first before we drill down into the really specific ones. We've enabled the Q&A function and on the Zoom call, and what that means is because there's so many of you, we're not going to be able to let you get on video and ask your question, but you can type in your question. You can type in your question, and when the attorneys who are not speaking see your questions, if they feel like they can answer them, they'll type in an answer for you. At the end of today, we're going to make the chat transcript of today's call available to all of you. We're going to get these questions and answers up on the Court Buddy blog. We're also going to get this up on YouTube. So we're going to do our very best to get this content out to you. We're also going to be holding future meetups. So with that in mind, that's how it's going to go. Let me introduce my panel. Bowen, can you introduce yourself to everyone, please?
Yes, my name is Bowen Klosinki. I'm a bankruptcy attorney, corporate attorney, real estate attorney in Augusta, Georgia. and I'm here to help out with any mortgage and bankruptcy questions that our participants have.
Great, we appreciate that. Ifan, can you introduce yourself, please?
Yes, thank you, Jennifer. Good afternoon, everyone. Happy Friday. My name is Ifan Cobb. I've been an employment law attorney for more than 10 years representing workers and their work-related issues here in the state of California.
Neil.
Good afternoon, everyone. Neil Abdul Lopez, former JAG, did 6 years active duty in the Marine Corps, transitioned into private practice. And as a former prosecutor, I nested in criminal defense, specifically specializing in DUI defense and family law. Thank you.
Great. Bradley. Oh, Bradley, you're doing what we all do, which is speaking on mute.
I'm sorry about that. My name is Bradley Bailyn. I'm a small business attorney here in New York City. I deal with a very wide variety of matters that can come up. Right now, commercial landlord-tenant is the largest portion of my practice, and I deal with the universe of that, from getting the right space to begin with and negotiating the right lease, down to escaping liability through personal bankruptcy and renegotiating leases, and everything having to do with the commercial landlord-tenant process. Thank you, Jennifer.
Of course. Michael.
Hi, I'm Michael Barnes-Newman. I'm a solo practitioner based in New York City. I've previously practiced in Chicago as well in landlord-tenant law. I have various experience as a renter in New York City, so I can speak to that pretty well.
We'll have a lot of questions for you today, Michael. Lou.
Hi, Jennifer. Thanks for having me. Hi, everybody. My name is Lou Russo. I'm a solo practitioner in New York, barred in New York, New Jersey, and Washington, D.C. I'm a business attorney, so I focus on business transactions and disputes. Could be anything from partnership disputes, fights with commercial landlords, or employment contract issues. I'm here today to talk a little bit about some of the government funding options that are available and other ways that you might be able to consider recouping money during these turbulent times.
Great. We so appreciate you too. Patricia.
Yes, hello. My name is Patricia DeFonte. I'm an estate planning lawyer here in California. It's important to remember that whatever it is that we say here today is not legal advice. We can't give you legal advice. The answer to any question in the law is always, it depends. And it really depends on us having hours and hours and hours worth of facts. So while we're really looking forward to getting all of your questions, just please remember that you can't really rely specifically in your situation on anything we might say today. Estate planning is about what you have, who you love, and who is counting on you. And I'm looking forward to your questions.
That's great. Thank you so much. Patricia just anticipated what I was going to say to everyone, which is what we're going to do today is I'm going to read questions that come from real people. They type them in and I'm going to read them out to you guys verbatim. So these are real people with real problems and how they describe their problems. And guys, everyone listening in, we are so aware of that and we really want to help you. But you do need to know that your legal rights and how strong your case are is going to depend on certain things. It's going to depend on the circumstance you find yourself in. It's going to depend on whether or not there are any documents that govern your rights, and it's going to depend on where you live. So for example, if you are a tenant and you're having an issue with your landlord, your rights are going to depend on the circumstances that you're in. So what is happening? Have you paid your rent? Has your landlord locked you out? Is your apartment habitable? Those are the facts. It's going to depend on your lease because your lease is a governing document that's going to give you rights. And it's going to depend on where you live, even the city that you live in, because New York, for example, has tenant protection laws that might not exist in Atlanta. So there are 7 of us here today, and we are going to answer your questions, and we are going to give you some practical advice. But you really do need to know that it does behoove you to take an hour of your time and to talk to a real lawyer who can read your actual documents, listen to all the facts that you're going through, understand your circumstances, and be your ally and give you a real plan of attack. We are trying to help, we'll be give you the best information that we can, but you should always consult with a lawyer. All right, that said, Patricia and I and everyone else here on the panel is in alignment on that. Let me launch in and start reading some questions. We're going to start with questions from Michael, our residential landlord-tenant lawyer, because those are about 60% of the questions, if not more, that we're getting right now. And I told you, I promised you, I was going to start with the questions that are most top of mind. So Michael, here's a question for you. Can my landlord evict me if I fall behind on my rent during COVID-19? Can he charge me late fees? And can he lock me out?
So several things, as Jennifer so specifically said, it depends. Excuse me, I think that was Patricia. The answer always depends. Your lease is what's going to be controlling here. Remember, it is a contract, just like anything else. Late fees, if they're contained in there, it depends what jurisdiction you're in. Right now, New York City is banned late fees until August 20th. They've also put a moratorium on evictions for non-payment, but really of any kind, because they're not accepting new filings. So the answer to that, in short, is no, but it also depends on where you are. What was this last part? Can he lock you out? No. Illegal lockouts are actually one of the few things that housing courts are open for if they're not closed. So if you do come home and your landlord has locked you out, first call 311. Tell them the situation, and then I would, in the morning, call the court, wherever you are, a county, and tell them the situation and ask them what you think you should do. Because generally, there'd be an emergency style motion where you can get on the calendar quicker, maybe even that day, where the landlord will have to appear if you can show that you served them and have to answer to it. They also, depending on jurisdiction, may just send a marshal and a sheriff to let you back in. If you call 311 in New York City right now and you say someone locked me out, it's likely that the sheriff or a marshal, whoever is the governing body in the county that does municipal stuff, lockouts, anything that involves property residential wise, they might just come and let you back in. So I would first look at your lease for those questions. Again, maybe consult with an attorney if it gets dire enough or if you're worried, or if the landlord locks you out, I would call the county court or the city court, wherever you're located, in the morning.
Great. Thank you, Michael. You've answered multiple people's questions there, so we really appreciate it. My next question is one that I think both Michael and Bradley are going to have some thoughts on. I'm going to start with Bradley. He is a commercial, handles commercial landlord-tenant issues, and I think this is popping up both on the commercial side and the residential side, which is from the tenant's perspective. Do I pay my rent? And if I cannot pay my rent, what are my options? How do I get my rent reduced?
Okay, so I'm going to begin by answering this. This is Bradley Balyn's 5 steps for dealing with this issue that I get called about almost every day. The first thing, as you alluded to, Jennifer, is that you need to look at your lease and see if there's a force majeure clause or any other clause that might help you, and what exactly the language is, because everything starts with the lease.
So
the next thing you want to do is...
Bradley, what is a force majeure clause?
Oh, sorry. A force majeure clause is a clause that basically deals with what happens when something that nobody expected, which is extremely severe, such as a pandemic, affects your ability to make use of the space or affects the space in general. So it could be a strike, a tornado, an earthquake. It's basically something terrible that really interferes with the lease. Is that clear? Is that a good explanation?
Yes, that's great. Thank you.
Okay. So this would likely be considered a force majeure. However, a lot of times that goes in favor of the landlord. The next thing you want to do is examine your state laws, and in particular, the executive orders. Here in New York, we have an executive order that makes it so the landlord cannot evict the tenant. And that was recently extended So that puts a lot of pressure on the landlord, because even though there's a lot of things the landlord can do, evicting you is not one of those things. Next, you also want to research the landlord and see what kind of mortgage is on their building, see how litigious they are, evaluate, basically think about it from the landlord's point of view and evaluate what you think their options are. Because you have to remember, this is personal between you and them. So if you see they sue everyone under the sun, you know it's coming. If you see that they rarely sue anyone, that also gives you a pretty good idea of how things are going to go. Then you want to evaluate, what are your risks? Have you signed personally? Would filing personal bankruptcy kill you if you have to do it? Do you care if you lose the space? And finally, evaluate your own financial position and then do what you need to do. If you're going broke and you're running out of cash, then you may have no choice. The one thing people should keep in mind is that, at least here in New York, even though the landlord can't evict you, the landlord can fully terminate the lease. And as soon as the courts open up again and the moratorium on evictions end, the landlord can evict and then sue you for the full balance due under the lease. So this is certainly not without risk, and you should absolutely consult an attorney before moving forward.
Thank you. Those are really cool steps.
I'd like to echo
And
that.
Michael, yeah.
So if you can't pay your rent because you don't have enough money, don't pay your rent. It's just that simple. You owe the money, you will owe the money, you're under contract. But I would advise, and this is for every state, call your landlord, get them on the phone, try to talk to them, tell them your situation, tell them, you know, where your finances are at, when you expect to be hired back, why you lost your job. If there's not much time left on your lease, like Bradley said, you may be able to get out of it because, you know, a global plague is kind of an act of God. And if you have 3 roommates, that may be considered uninhabitable now. If you're told to shelter in place and isolate, it's kind of hard to do with 6 other people or 4 other people or whatever. So I would suggest trying to cut a deal. I would be honest with them, be upfront, and depending on the jurisdiction, just know that in one instance, and probably the last time it's going to happen in a while, you do have some leverage and you do have an upper hand. And I would think about yourself and take care of your family.
Really good practical advice. All right, we do have many more landlord-tenant questions, but I'm going to, like I promised, jump around a bit. And I'm going to ask Ethan some employment questions. Ethan, I have 2 fact scenarios here. They're somewhat similar, but they speak to something that I feel is very real for people who are employed right now. I'm going to read them off to you. The first question is this: I work in a nursing home. I'm doing housekeeping. Am I an essential worker? And do I qualify for some sort of COVID-19 hazard pay? Here's the second question. It's very similar. It's a sad and similar story. I am an assistant property manager and was told that I could not work from home during COVID-19. They gave me a paper to carry around stating that I am an essential worker, and I don't know if that's correct. My site at that point in time had 4 known cases of COVID-19, and even though my company called someone in to clean the common areas, they also still required me to come in. I started to risk my health by going to work every day. I tested positive for COVID-19 on April 21st.
Wow.
My coworker, who shares my title, refused to come in, told HR she had rights and she hasn't been laid off. How is this fair? I have been told to come back to work after my 14-day quarantine period ends. What do I do?
Absolutely. That is a tragic, tragic story that's being played out over and over again all across the country, especially the latter question. And my approach to addressing any question on here is to let everyone know, to reiterate with what Patricia said, is I'm a California attorney. The worker rights for employees in California are some of the strongest in the country. So my advice will be based upon federal law, which is the minimum, which is the basic minimum across the country, worker rights of what people receive. And unfortunately, in times like this, they're not the strongest, frankly. And so, so we'll go and turn. I'll start with the first question regarding the healthcare worker. As far as essential worker guidelines, the federal government issued guidelines for states to then, upon their own legislative act or executive act, determine who is an essential worker in that state. So the federal guidelines they're just guidelines. There's no enforcement mechanism behind the federal government's opinion of who's an essential worker. So my advice would be, depending on what state you're in, that would be unfortunately a Google search, your state and essential worker, am I essential worker in your state, and hope that the governor of your state actually made some kind of public statement regarding who's an essential worker in your state. And that has been very frustrating for workers when I speak to them, and I have spoken to some. My law firm has been inundated, as you can imagine, and that has been one of the more frustrating aspects for workers. What am I? Am I essential or not? My employer is telling me I'm essential, but am I? And your employer is not the law. So your employer doesn't, if your employer tells you you're essential, I would ask, okay, please cite your source. Where do you get that? Is there a website you can point me to? Because I don't think as a property manager, I'm necessarily an essential worker. Healthcare worker, that one maybe that's a stronger possibility. So that one really is, it depends, and you would have to either look that up or as we have been advocating this whole time, reach out to an attorney, a local attorney in your state or in your hometown. And so being tested positive for COVID, knowing that your coworkers are positive for COVID, there are some federal protections that you have. First and foremost, I always tell everyone, you don't need to be in a union to gain protections from the National Labor Relations Act. The NLRA, which is the law, which is the statute upon which unions do move from to help them unionize. You don't have to be a union to raise those protections. You just have to act concertedly. Concertedly means 2 or more workers need to go to management and make some formal complaint about their conditions of work. You do that, and I would highly recommend you do it in some way that there are either witnesses or it's in writing. You want to document, but you want to get another worker who's concerned about their work, your general work safety or any conditions or terms of work. Sounds like you have a coworker that already raised that concern, and that's a good thing. The both of you can work together to approach management and say, "Hey, we both want to work from home. We're property managers, right?" And I don't want to muddle the two questions, but for home and I guess hospice worker or healthcare worker, again, that's you can raise that issue with your coworkers. You can use it as well. I know if you're an essential worker, maybe their employer has more leeway, but it's worth doing. It's worth doing. You have a voice as a worker. You have rights, always, in emergencies or non-emergencies. You have rights. I'm sorry, am I?
No, I was thinking that another thing that I saw coming up on the Q&A and that also I think was asked by the woman who was working in the nursing home is there such a thing as COVID-19 hazard pay? Do you compensation for, extra compensation for the work situation that you're putting yourself in and the risk you're taking doing your job?
Unfortunately, there's no law that requires employers to pay hazard pay. There is not. No federal law. And I don't even, from my research, I don't see there being a state law either. It's really based upon the employer. And in these times, people workers that I talk to, they react incredulously. How is that? But, that's the state of employment law in most of the country right now. So it's not necessarily a right, but again, you can and we're seeing it on social media. You're seeing these social media worker rights pushes where people like Amazon and where Target are asking for hazard pay. They're demanding it. That's National Labor Relations Act protections because they're acting in concert. That's why it's important. Those movements are important to be publicized because that is showing that they are acting in concert. OSHA is a big one that people bring up a lot. It's federal law. It's federal safety. Again, how that affects essential workers. This is the most unique situation that any lawyer any of my mentors who have 20 or 30 years experience have ever experienced. So how it works, honestly, it's guesswork still. Still raise the issue. Still raise the issue and document the issue. I fear for my safety here. I have 4 other coworkers who have COVID. I'm terrified. Put it in writing. OSHA might be an avenue of protection. And lastly, FMLA. But FMLA is very specific. It has to be an employer that employs more than 50 people who all work within a 75-mile range. But you can raise the Family Medical Leave Act. That's what it stands for, FMLA. And you can say, look, I'm sick. I'm still sick. I have COVID. I'm still sick, so I'm requesting FMLA leave. That's one way of approaching for the second question of approaching getting additional leave on top of your 14 days.
Got it. Thank you very much. All right. So now I'm going to ask a question to Neil that I alluded to when I gave my opening remarks because I've gotten many, many questions on this topic. The facts vary slightly, but basically this is what people are asking is about visitation rights with their kids during the pandemic. So here are 3 related questions. 1, I need to file for visitation with my son, but I don't know what my rights are right now. What are they? 2, can my girlfriend take our kids and not allow me to see them during the coronavirus shelter-in-place orders? 3, I need help getting my kids back. Their father left town with them, and because of this coronavirus, he says that he doesn't feel that it's safe to bring her back home right now. He has custody. What can I do?
Okay, so I'll kind of answer them in kind, and obviously in accordance with what all my colleagues are saying. I need more facts to really answer that in a detailed fashion. But the first overarching one, what are your rights? The family code itself, I'm sure in every jurisdiction, hasn't changed. So your rights in any court awarded decrees or judgments still stand, regardless of whether the courts are closed. Your rights are the same. The fundamental right of keeping the family together, again, that is a fundamental right. So as I understand it, I think, and this goes to number 3, so I'm actually skipping around here a little bit. It looks like I think your father-in-law or someone close to you has actually taken your child, but then, and I'd need to know whether they actually have physical or legal custody. But if you have visitation rights, those rights still remain. So you should have the same access that you always had, according to whatever that court awarded decree states. So, and I'm sorry, can you say the second part again?
Sure. I threw 3 different questions at you, and I apologize for that. And it's because so many people are writing to us with a variation of the same question, which is one partner has the children physically and the other partner does not have the children. And then the coronavirus pandemic broke out, and the partner who is not living with the children is being told by the custodial parent, I don't feel comfortable shuttling the kids back and forth. I don't want you to see them. And the non-custodial parent is asking what are my rights and what do I do?
So
So
I actually can answer that very specifically. I'm actually dealing with that very scenario with several of my own clients. Because the courts are closed, and even defining the few cases that the courts are hearing, known as ex parte or emergency type orders, we really can't get in there to enforce those rights or request for further court action in any punitive type measure in family law courts, at least here in LA County where I practice. And so the best thing to do is try practical mitigation. And what I mean by that is, first speak to that co-parent. You try appeal to their logic and reason, but again, there's no new orders or legislation law that has passed that change the way business was done before this pandemic. So your rights persist, and I don't ever advocate for going and doing something about it yourself. That's only going to make the matter worse, and trying to go pick up your children physically. But involve law enforcement and reach out to any and all practical measures you can. In some cases, there's mediators or family counselors. Like in my cases, there's both of those, and so that's a good practical force or measure. And it actually worked in ours. The mediator reached out and was actually able to speak some sense into the father that was refusing to bring back, their child according to, what the court awarded. So hopefully that answers everyone's question. I know it's very general, but, in accordance again with what my colleague said, no living person has ever faced anything like this in our lifetime. The last pandemic that had this type of impact was the Spanish flu of 1914 and 1918. So there's a lot left to be decided. Thank you.
no, it's a great answer, Neil. I mean, you're basically saying your legal rights are unchanged, but we're in a circumstance right now where the courts are closed, and what you can do about your rights is compromised, but always try the human touch. Similarly to what Bradley and Lou were counseling, reach out to your landlord and work on your relationship and try to work something out. Practically speaking, that's my bottom line advice, and that's what you're saying between co-parents. It's good advice. Patricia, I'm going to ask you some questions if I may.
Sure.
One of them is, what are the most important legal documents to have in place right now during the COVID-19 pandemic?
I would say right now, the most important documents, since we can't follow our loved ones into the hospital, whether they're going in for COVID or just about anything else, are advanced healthcare directives and HIPAA waivers. You can usually get these for free. Almost every state that I'm aware of has statutory forms for this. You can also get them from your doctors. Here in California, we can get them from Kaiser, UCSF, from all the major medical facilities. It's critical. And these are things that you should share liberally with your loved ones, and you should get copies of those from your loved ones. And really just save them on your phone. Make sure that you understand what the people who are important to you want to have happen if they can't advocate for themselves, and that you understand really end-of-life decisions right now and what should happen to someone's remains, and especially communicate what you would like if you think that maybe your spouse and your mother may not agree. We need to preserve family harmony in a time like this.
That's really good advice. If you do have elderly parents and you're concerned about them or their health right now, what's a productive way to begin a conversation with them about getting these kinds of documents in place, or even more broadly about estate planning?
Sure. Often when we try to talk to our parents about their estate plans, they get the feeling that we're trying to determine how much of an inheritance we're going to get, or that we are mentally walking around their home and putting stickers on items that we would like to have for ourselves. It's really important not to talk about the money, but to couch the conversation in talking about asking your parents what their wishes are for themselves, making sure that they understand that this is about them maintaining control, that you don't want to have to go to a judge to get permission to take care of them, that you'd rather that they create documents with a lawyer that spell out exactly what they would like to see happen, so that if they're incapacitated and they can't take care of themselves, that you or someone else that they really trust is already in a good position to be able to do that without interference from the courts.
All right, Lou, we've talked about this. It's very top of mind for small business owners right now. Some of the nuances of the law I know are up in the air and ambiguous, but I'm going to ask you because it's pretty much almost all of the questions that we get from our small business owner clients right now. If it's not, do I walk away from my lease? It's a variation of this. How do I know if my business is eligible for a payroll protection loan? What portion of a payroll protection loan is forgivable if I do get one? And can you give me some advice on how to account for my payroll protection loan money once I get it?
Well, again, thanks for being here. And I'll follow Patricia's lead and say that, again, this is all basically a consultation that I'm doing my best to, give you the facts as I know them about the available funding out there. But to the extent you have questions about your specific businesses, you should be consulting with an attorney and perhaps an accountant. A lot of my clients have been relying on their accountants because, as I'll mention, your eligibility is dependent upon certain financial metrics, which the accountant probably is best situated to put together for you. So as far as who's eligible, I want to say that if you Google the PPP, you'll get 1,000 summaries of it. But if you go to the SBA website, the Small Business Administration website, they do a good job summarizing it. But in short, if you have 500 or less employees and you qualify under a certain type of business, there are certain businesses that are excluded from being eligible, and it's a laundry list of businesses. But most normal businesses do qualify, and the loan is designed to help you prevent you from having to lay off your employees. Obviously, the Paycheck Protection Program is designed to let you keep your employees. So, what exactly is the payroll cost? It's laid out in a certain list of certain things. Includes, I'll read a few of them: vacation time, leave time, benefits, group healthcare benefits, retirement benefits, state and local taxes, assessed on employee compensation, a whole host of things. So, an accountant can help you figure out the number that you're eligible for. But the biggest question that I've been answering for clients is, the forgiveness question. And I'll give you the caveat. We had a prep call for this webinar. We talked about this. It's really hard to say how loan forgiveness is going to work in this situation because we don't know how it's going to be enforced. I have not seen the loan agreement, so it's hard to advise on exactly what potential consequences there are if you violate the terms of the loan. But in essence, 75% of the amount of loan that you take can be forgiven so long as it's used for the qualified costs that I mentioned, the payroll costs, which includes a bunch of things that I mentioned on the payroll side, but also could be mortgage interest, could be rent, utility costs. But so if you wind up laying off any of your employees, you could lose eligibility. So a lot of people have been asking, what do I do if I already laid the people off? I think the statute allows you to bring those people back. Lots of permutations of, well, what if someone doesn't want to come back? Unfortunately, there's no answers to that question. But the accounting part of the question, the last part that you asked, Jennifer, is a good one. And it was one of my colleagues, I think it was Bradley, who mentioned this yesterday, which I think is a really good idea. A lot of clients apparently are, if they get the money, they're opening a separate bank account, and they're using that bank account to pay only the qualified expenses that you can pay through the loan. So if it comes to it where someone, and when this happens, I don't know, whether it's at the end of year tax filing or some other process, in some sort of investigation into how you use the funds, if you are using that bank account, which is funded solely with the PPP funds, then you should be able to say that, as you can see, I paid for all of the things that qualify: payroll, mortgage, rent, things of that nature. So that's one way of doing this. But again, I would recommend not only speak to your lawyer, but you also speak to your accountant, because the application process, if you haven't went through it, requires a calculation of your payroll costs from the prior year. You're entitled to 2.5 times that amount. There are resources out there that have created calculators for people to do that on their own. If you go on my website, there's a chart that lays out all the different programs and some of the resources. But again, I would probably encourage you to speak to your accountant who can, do the calculations for you. So, if you are filling out the application, you're not taking more money than you're entitled to.
Right. And that's really a good consult, especially on a law like this. It's good to consult with your attorney. It's good to consult with your accountant. You also brought up something that I think makes me think I should let everyone know. We did prepare for this call today, and so many of us have resources that we think are helpful and useful for people. So I just want everyone to know that we're going to be posting blog articles up on the Court Buddy blog. If my colleagues thought they had a particular article from a colleague or by themselves that really spoke to topics that are top of mind right now, we're going to be getting that information up there for you. We also have a resources directory at www.courtbuddy.com. We keep it up to date. It's up to date daily. It has all these things like the website that Lou was just speaking about, the Small Business Association website. The best place to go, by the way, for information on the payroll protection loan is home.treasury.gov/facts. And all of my colleagues are going to be sending me links to useful resources on that they have and that they've compiled for their own clients that are up on their websites. And we'll be getting that information out to you guys. And I appreciate all that work, everyone. Bowen, I am going to ask you questions. I'm going to start out with a question that I've heard a lot, and then I'm going to ask some follow-up questions. The question that I've heard a lot is a variation of, I'm unemployed. What do I do right now? Do I live on my credit cards if I have to? And sometimes people are a little better resourced and they're asking, do I borrow against my 401k or my IRA right now to see me through?
Sure. So I guess I'll start with the credit card question and whether or not I should live on my credit cards. That is going to be dependent on what everyone's situation is. If that's the only thing you can live on right now, and you're not receiving, and for some reason you're not receiving an unemployment check, then you really don't have another option. Then I guess that's what you have to do. You always try to advise people to avoid credit card debt as much as possible, but if you can't do it in situations like these, then it's really your only option. You need to, after it's all said and done, and we can get back into employment after COVID, and that credit card debt has reached the limit to where you don't think you'll be able to pay it back at a reasonable time, then you can look into a Chapter 13 bankruptcy, which will allow you to pay back your credit card debt over a period of 5 years. And that's not only your credit card debt. If you have a car loan, you can expand that car loan out for another 5 years. Similarly, if you were behind on your mortgage, the arrearage you build up in your mortgage, and when you file a bankruptcy, you will be able to pay that arrearage over the next 5 years. That's kind of the benefit of what a Chapter 13 bankruptcy will do for you. So I guess the point is, living on your credit cards is, if it's the only option, then that's kind of what you have to do. And when we get out of this, when you get back into employment, looking into a Chapter 13 bankruptcy and discussing those options with an attorney are what you're going to need to do. With the IRA and the 401k, should I borrow against it, or should I just pull the money directly out of it? Again, that's going to be dependent on what you are comfortable with and what you just basically feel comfortable with. If you go and just pull it out and use that money, then fine. But all that kind of hurts you on the back end with, because now I have taken money out of my IRA account, and how am I going to be prepared in the future later when I need to retire? If you feel that you need to do that, and then you're going to be able to put that money, replace that money at a later time, then maybe go with that option. If you feel confident in borrowing against it, so that if you do default later, they just come and grab the money out of the IRA account, then go with that option. It's definitely a comfortability in what you're comfortable with answer. If you default when you borrow the money on the IRA account, they will just come in and take it. That's kind of, basically just a comfortability question on what you want to do. And Jennifer, what was my next question?
I'd asked if people should live on their credit card debt if they need to, and then would borrowing or taking money out of an IRA or a 401k be a solution? I think you said that, the issue is if you take money out, you're going to potentially be aware that down the road, you're not going to have money to retire on unless you can replace that money. And not to anticipate your train of thought, but I think you might have also been thinking about the fact that people have to pay penalties on the monies that they draw out.
Sure. Yeah. I definitely missed that. But if you want to borrow it, I think that's probably a good option. But it's definitely, once again, it's just what you're comfortable with.
All right. So here is another topic, some other questions that have come up, and I'm going to ask them and then see if, Bowen, you feel like you're the one to answer, or maybe Bradley or someone who's had some experience on the real estate front. We'll see. It's similar to what if I can't pay my rent. It's what do I do if I cannot pay my mortgage? And does the moratorium on foreclosures end when the shelter in place orders end? When does it end? And what happens next?
Yeah, I'll take the lead. So if you can't pay your mortgage, I guess I'll start with the moratorium question. I'm pretty sure, I'll let everyone else back me up on this. I'm pretty sure the moratorium ends on May 17th. But then again, those foreclosures are only, moratorium only applies to mortgages that are federally backed, which I think we've discussed previously. If you can't pay your mortgage, the first thing you need to do is call your lender and speak with them directly and ask what kind of forbearance programs they have or what kind of assistance they can offer you. The forbearance programs are kind of differ depending on the lender and what your particular circumstances are and what the lender's comfortable with. Some forbearance programs will allow you not to pay during a particular set of time, but at the end of the forbearance period, you're going to owe all that money that wasn't paid. So, and they'll sometimes either ask for it all up front, or you can create a payment plan where you're paying more than your mortgage to be able to catch up the arrearage. Similarly, in a bankruptcy, a Chapter 13 bankruptcy, if you get a notice of foreclosure, the way to stop that foreclosure is to file the Chapter 13 bankruptcy. Once you file it, it allows you to catch up your arrearage over 5 years, 3 to 5 years, and while you are making direct payments in the meantime. Is there anything else?
I think that's right.
The only thing I might add is that this sometimes can be a little bit tough, because when you're to do a Chapter 13, you need to have a regular source of income, and unemployment is not necessarily considered a regular source of income. So if you lost your job and the bank won't cooperate with you, you may need to be in touch with your real estate broker to see if you can sell your house. It's not something you would want to do, And certainly speaking to the bank is the first option, but you shouldn't necessarily relax and be like, oh, I'll just file a Chapter 13, which is what a lot of people think they're going to do at the last moment. And, then it turns out that that's just not a sustainable solution. So you really need to, if you're thinking about that, talk to the bank and then talk to a bankruptcy lawyer in your state.
Absolutely. This is a major asset. This is your roof over your head. If you find yourselves in this kind of situation, it really, really behooves you to take the time to talk to a lawyer to make a plan. All right, so I'm going to ask Ifan some questions. We covered some employment related questions. We have a whole bunch of unemployment related questions. So Ifan, here's the basic question. For how many weeks am I allowed to get unemployment money after I've been laid off? And how do I get health care after I've been laid off?
Yeah. So depending on your circumstances state by state, again, I can't address the state unemployment because there are certain parameters and certain requirements. Federally, which is the $600 weekly amount, it's a 10-month funded program for individuals. So you can get 10 months through the federal program. So for instance, I have clients out here in California who have called and asked me about the California setup. So once you apply and you are accepted for unemployment in California, you have a max of around $450 through the California unemployment program. And then the federal kicks in, so you can get a max of around $10,050 a week unemployment, which living in California is much, but it's something. And so that is for California, however. Again, depending on the state you live in, that amount from the state might vary, but the federal amount maximum is $600. I think it's actually just $600. You get it. Healthcare, unfortunately, there's no COVID relief for healthcare. So you do have options, but the options are basically the options you would have whether there was a COVID pandemic emergency or not. First is to get on the exchange, to apply through the health insurance exchange and try and get healthcare that way as an individual. And of course, that is going to be more expensive than if you're under a group plan through your employer. It's, it averages how much more expensive it's going to be, but it's going to be at least, 25 to 33% more. And secondly, COBRA, that's an option for a lot of people. You can pay the COBRA program that kind of locks in your rate through your group plan through your employer. Those are basically the two options for healthcare if you lose your healthcare through your employer.
Got it. All right, here's another question. Is there a way for me to get lost wages back since I am on reduced hours due to COVID-19? And here's a similar question. I am furloughed for 1 week a month. Can I claim unemployment for that lost week?
Okay, so the first question, does your employer owe you the wages? No. From what we see with this, how COVID relief works, no, it's either unemployment or nothing. So no, your employer isn't on the hook for your wages unless there was a legal violation. But that's litigation. That's something different. When it comes to just statutory rights of compensation due to the impact of your income from COVID-related issues, no. Secondly, furlough, 1 week a month. That you would be. I mentioned it earlier. The federal minimum, you would be owed the 1 week a month. You would have to apply for unemployment and receive your weekly amount, at least the federal minimum, and then again you might satisfy your state's unemployment insurance requirements and receive state unemployment benefits as well as federal.
Got it. All right, I'm going to ask, oh,
Sorry.
go ahead, Michael.
What Ethan said, that's a good point. The last thing that he said there, just know that, depending on your state, you may have to, or you may have the option to sign on or call once a week. And in New York State, it's called certifying for benefits. So you can get benefits even if you're partially employed up to 34 hours a week. So if you all of a sudden got a bunch of work, you would just tell them your claim would remain open, and you'd continually sign on weekly to say how much time you worked, how much money you made, and they would adjust your benefits to that.
Got it. But this varies, whether or not this
Very
is available to
as
people.
much as anything, yes.
Got it. Okay. Here are some questions for Bradley and Michael, and I'll tell you the topic and you can tell me who feels comfortable speaking on it. The topic is basically looking at the landlord-tenant relationship from the landlord's point of view. So here's a question. How do I address a tenant who is breaching his lease? And a similar question, can a tenant be evicted if they do not appear to be suffering any financial hardship due to the coronavirus? Do they have to prove that their income has been diminished due to the coronavirus in order to avoid eviction?
For residential context in New York, I'll just start with the first question on the breach. It depends on how they're breaching the lease. If it's non-payment, then once the courts open back up, if they are closed, it would just be any normal non-payment. They haven't paid their rent. At that point, it would be on the tenant, depending on what state, to say, I lost my job, I didn't have the money, I need to get caught up. And generally, most housing courts will then try to work a deal. So it would probably behoove you to try to work a deal with the tenant from the start to save yourself some time and energy. We told the tenants that everybody's gonna have to work together. If you think someone's fully gainfully employed and they're just not paying their rent to take advantage of the situation, well, it depends if the courts are open. Depends on what state you're in and what city you're in and what they've said the standards for non-payment are and when that's lifted. If it's a breach of a term, like let's say they're, making a lot of noise, you would, in most states, have to serve them with what's called a notice to quit. Generally a 10-day, 15-day, something along those lines, where they're given an opportunity to amend the situation or fix it or stop doing it. Now, depending on what kind, if they're selling drugs, it's kind of hard to stop doing that activity, and that might not qualify in this instance. So it depends on how they're breaching the agreement. And what was the last part of the?
They're asking if a tenant would have to prove that they had a loss of income due to COVID-19 in order to avoid eviction.
Well, they still owe the money, so it doesn't really matter whether they can prove anything anyway. There's a contract. Don't forget that. You have a contract. They say, if I use this property, I owe you the money. If they're using it, they owe you the money. It doesn't matter whether there's a pandemic and they've been affected or not at this point in time. There's not been rent waivers in any city or state that I'm aware of.
And I would just say for commercial, it's a very similar analysis. And, I represent a lot of landlords as well as tenants. And that is something I often need to do, is reach out to the tenant and explain, right now you feel pretty good because no one is making you pay your rent. But sooner or later, you're going to be held accountable to pay all of that money. It's not a gift. It's just temporarily the landlord can't necessarily enforce all of their rights. So I would advise anybody that if you feel that you've been knocked out and you can't recover, or you have a real problem, then you need to assume that the money is due now, even if it's not, and really negotiate with the landlord and prepare for what your next step is going to be.
Jennifer, may I say something?
Yes, please.
One thing that I've found effective from a landlord's perspective, and by the way, I represent both sides more recently of tenants, but if someone claims that they don't have money or the business has been affected financially and adversely, one of the first things that I've seen to be effective is, well, have you filed for a PPP loan? Because if 75% of PPP funds are forgivable if you use them for qualified expenses, one of which is rent, then one of the ways to minimize your loss is to say, well, willing to work with you, willing to give you an extension, as Bradley said, because you're not going to get out of the lease obligation and the rent obligation. But if you could recover 75 cents on a dollar by saying, go get the loan, you might cover your loss a little bit better. And it's an easier solution, especially because the money's not coming from the tenant themselves. But that being said, they still have to pay back the loan. I mean, if the one thing to consider that I didn't mention before is that, if you have the financial wherewithal 6 months after you get your loan to pay back the loan, then you're required to pay back the loan. So, I don't want people to think it's free money. I think that's a mistaken belief about the program. But if your financial impact on your business lasts beyond that, and you can show that you don't have the money to do it, then it will be forgiven. And if you give $1 to a landlord for rent, then 75 cents of that dollar won't have to get paid back.
Right. That's a very good point. So let's talk a little bit about some actual money that doesn't necessarily have to be paid back. Like one of the few things that's been done for folks right now, which is the tax stimulus checks. We've gotten some questions in about the tax stimulus checks, and let me find them. They are, why didn't I get my tax stimulus check? I need to do something affirmatively to apply for it. I thought it would be deposited into my bank account automatically. Bowen, do you feel like you can answer this question? Oh, you're on mute.
Say that question again.
Sure. So it's about the tax stimulus program, and it is, why didn't I get my tax stimulus check? Do I need to affirmatively apply for it? I thought it would be deposited into my bank account automatically.
Okay. It's definitely depend. Did you file your taxes? Did you file them in 2018? Did you file them in 2019? Who did you file them with? Did you receive your tax refund via direct deposit? The way, or what I've understood is that the money is being deposited through the bank account that you use to receive your tax refund. Sometimes they are being mailed. I'm not sure if people have received them in the mail or lately, or if it's going to happen. I think I read something that said they were mailing them out in early May, so they may be in the mail. I've also seen that if you owe child support, you are not going to get your stimulus check. Other than that, you're gonna have to go check with who you file your taxes with. That's kind of where I've understood where the problems have been in receiving the stimulus check. And I'm definitely gonna open it up to anyone else here who has any other understanding of why people haven't seen their stimulus check.
Right. So it's, are you eligible? And did you pay your taxes? And go online to the IRS and see if your address and bank account information is correct and updated. That would be, I think, the first sort of pragmatic thing to do. Anyone else want to chime in? Yes, Ifan.
I do have friends who have not received their check yet. So, and they anticipate fully receiving them. I don't know if there's been an official statement made by the IRS saying that all checks have gone out and should be received. But I know that as far as the rate that my friends and I received our checks, pretty staggered.
Right.
TurboTax, everybody that filed with TurboTax was apparently delayed. I knew that. And then the actual administration has been shoddy. I filed my 2019 taxes the first week in January, and they said that it was going to go into the account that you elected to have a direct deposit in on your most recent tax statement. And mine went to an old bank account. So they're, all over the place.
Got it. here's some related questions. Neil, I thought you might be the one to answer this, but if you don't, if you can't, let us know. Because it's tangentially related to family law, but it's also sort of a stimulus check question.
Sure.
Can I get any of my stimulus money back? I feel that I am financially destitute due to COVID-19, but because of back child support owed to my husband, everything was taken out of my stimulus check.
You know, I feel a little out of turn speaking, because it was my understanding under statute, or, you know, the recent legislation, that everyone got their stimulus check regardless. Usually if you owe arrears under any of the family law scheme, you know, statutory or court schemes, they will take it out of, you know, your tax refunds, etc. But I thought on this one, you got it. I know in one of my cases, there is a parent that owes arrears, but they still, despite that, they still receive the entire amount. So that doesn't make sense to me. I'm not sure if that's the case. And again, with the IRS and this legislation being so recent, we just don't know how enforcement is going to work out in the end. So that's a little perplexing there. You know, why it would be a disparity in application, why one of my clients received it. So I'm unsure.
So then in your experience, Neil, one of your clients, even though they did owe back child support, did get their full stimulus check, and then it was between the two parties to sort out between themselves how to deal with that money. And yet the person who wrote in here, I owed back child support to their husband, and had all of their, according to the question, had all of their stimulus money taken out to satisfy that. So we maybe there was already a wage garnishment order in place for the person who wrote in with a question. These are exactly why it's important to consult with an attorney. There is, you know, we're doing our best here to give you generally applicable answers and principles, but different outcomes can happen to different people based on their facts. So that's why you take your paperwork to your attorney and they help you sort it out.
Sure. And just the last piece on that, the more likely scenario there is they receive the stimulus check to their bank account, but because of some sort of writ or levy on that account, like you said, for wage garnishment, it got taken out on the back end versus anything to do with the IRS.
Right. That would make sense. Here are some similar questions coming up in the family law context. The first one, New York State is shut down during the pandemic. I lost my job. Do I have to pay child support? My child support was based on working part-time, and now that source of income is gone. I'm at the point that if I miss one child support payment, my driver's license will be suspended. Here's a more general question. How can I lower my child support payment? And then here's a, yeah.
Okay,
go ahead.
Go ahead.
I was going to read you all three, and then you can tackle them as you see fit, Neil.
Sure.
The third one is, do I pay child support? And with the courts being closed right now, affect the timeline to file a civil complaint to collect against me if I do not?
So I'll answer that last one first and kind of work my way back. Definitely, if you're in a position to pay your child support, absolutely pay it. You know, as we've already established, rights and obligations under the law haven't changed as of yet. We'll see what happens in the future. But again, I can't overemphasize that enough. Your rights and obligations under the law have not changed. So definitely pay it. And I guess the second part of that question is more of a statute of limitations question, which I'll answer with the first part, pay your child support. All right.
Yes.
Then I think the second one, can you say that again, Jennifer?
Sure. Sure. Sorry, I threw too many questions at you. I apologize.
No, no problem.
It's because I'm trying to get through as many people's questions as I can, and I know our time is limited, so that's on me. So I asked you, do I pay my child support, and can people come after me to collect since the courts are shut down? And you gave the very real answer, which is if you can pay it, pay it. Just pay it. The other two questions are more interrelated because as I read them, they have to do with people who have lost their income due to COVID-19 layoffs, and they're asking how they get their child support obligations reduced. So the first one was, New York State is shut down during the pandemic. I lost my job. Do I have to pay child support? My child support was based on working part-time, and that is gone. I'm at the point that if I miss one payment, my driver's license will be suspended. And then the second question was a more general one. How can I lower my child support payments?
Okay, so in order to change child support, which is always based on circumstance and context, you can always change or petition to change child support at any time. And that's done by an RFO, like a request for order or a modification. You're in New York, whoever's asking this question. I practice in California, so I'm not sure procedurally how that's done, but it would be done in the same
way,
as you had previously done in the first place. So work with that same attorney or the paperwork you have. And then, geez, Jennifer, I'm so sorry. Can you say that first question again?
Sure. I'm in New York State. New York State is shut down during the pandemic. I lost my job. Do I have to pay child support?
Again, so your obligation is yes, but considering the circumstances that there's over 30 million people who are now unemployed and seeking benefits, it's doubtful. And with the courts being closed themselves, there's going to be no judges, at least I see, reasonably, deciding in favor of taking away someone's driver's license at this point. Again, the courts are closed. So administratively and logistically, that doesn't seem like a realistic approach. And, only time will tell. But if you're in a position where you lost your job and you cannot pay child support, I don't see it being held against you in the future. These are unprecedented times. While the law says you have to, I think the reality is that courts are going to be very sympathetic to the 30 million plus individuals, in America that have lost their jobs. So I hate to answer in this way, but we just don't know at this point what those consequences are going to be. But I don't see, I see judges staying actions on taking away people's driver's license, or other privileges under the law in the meantime.
Right.
I agree with everything Neil said, especially with regard to the temperature of the courts when this all opens. And I just wanted to add that family court in New York State is currently closed for anything that's not emergency. So you couldn't even amend it now if you were able to, even if you had the right to, or even if your circumstances warranted it, you can't even file those documents now.
Thanks, Michael.
Got it. So that actually is an answer, I believe, to some of the additional questions I received. So let me just ask. It is a family law question, and it is, my son and husband do not get along at all, and now we're all stuck together. It's making me consider a divorce. Can you even get a divorce during COVID-19?
So again, the courts are closed generally, but there's exceptions to that. Like Michael said, like both LA and New York have limited hearings for ex parte and emergency type orders. I actually just filed a divorce this last week myself by mailing it in, because while the clerk's office is closed, they are still accepting mail correspondence, and at least in LA County, and I think most Southern California jurisdictions, you can still old school just mail in a check with the petition, the summons, etc., and get your filed and conformed copies back via mail. I still do that for cases that are courts that are just too far to drive or impractical. So according to the announcements by the court, they're still doing that. So I expect them to follow through on that very shortly.
Got it. So it probably depends state by state. as to whether or not the family law courts are open, and if they are only open for emergency motions, which many courts are, how that court defines an emergency motion. So more likely than not, they're going to be open for things like restraining orders, and whether or not they're open for things like divorce petitions is more variable. Depends on whether or not the court has defined that as an emergency motion or not. Or whether or not they're still accepting paper by mail, but not holding hearings. Yeah.
That's right. Thank you.
Yeah. Okay, Patricia, I have some more trust and estates questions for you. What is the difference between a will and a trust? What happens if someone dies without one? And what does it mean if a trust is funded? And what happens if it isn't funded? So I can break that down. I just threw a lot at you. What's the difference between a will and a trust, Patricia?
Okay. Actually, I'm going to switch it around a little bit, because what can happen if you don't have an estate plan is that you die intestate. And that means you don't have a will or a trust. Now, if you die intestate, different states have different rules about who gets your stuff. And then it depends, are you married? Are you in a registered domestic partnership? Do you have children? Are your parents still alive? And so you really need to go back and look at the state. And usually you can just Google, it's a fun term, you Google the table of consanguinity to see who you're related to under the statutes. And then you would just Google intestate succession in Florida, Michigan, California, wherever you're from. And it'll tell you who would get your stuff if you didn't do anything. Really important for unmarried couples, because often you want actually to leave your items to your loved partner, but what you're doing is actually leaving everything to your estranged father. And so you have to be careful there. There are two ways to make sure that the stuff that you have goes to the people you want it to land with. And one is through a will, and the other is through a trust. A will is a document that is lodged with the court after you die. So it's a public document. So you have to think about, am I comfortable letting anybody who's interested know that I have died, how much money I have, who I owe money to, because all of that comes out in the wash in probate court, who will receive my assets and when they will receive those assets. And if I have children and I'm naming guardians in that document, the names of my children and the names of the guardians, and sometimes people put in birth dates and addresses in this very public document. Sometimes a will is perfectly appropriate if you don't have a lot of assets and if all of your beneficiaries are stable adults, maybe it's okay. A trust is a very different type of instrument. It first of all maintains your privacy, because it's not the kind of document that would be lodged in a court unless there was litigation. So it's not, in the first instance, like a will, immediately going to be available for public viewing. It also lets you control when people get their assets. And so maybe you don't want your children to get their money when they're 18, because maybe they would go to Vegas with it. We know that about 33% of people lose their inheritance within 3 years of receiving it. And so what you can do with a trust is make sure that the people you're leaving money to get it in small bites, in small amounts. And maybe you want to leave money for them to help them buy a house or start a business. Maybe you want to pay for their education, a college graduation, travel to maintain contact with family members, but you're not as interested in just giving them large chunks of money. A lot of people think that they don't need a trust because they don't have a lot of stuff, but it's never about the stuff. It's always about who you're trying to take care of. And really, I have a lot of clients who, even though whether or not they make a good salary, are really relying on life insurance to be the primary asset for the revocable trust. And so during life, they're not worth that much. You know, the money is coming in and the money is going right back out. But were something to happen to them, because they have an insurance policy, there might be $1 million or $4 million for a surviving spouse or for the children on death. And in that instance, you can really craft a plan that pushes your values and takes care of the people who are important to you. The last question, without funding a trust. So when you die with a will, generally what happens is your bank accounts, anything that you can designate a beneficiary for, you know, we've all filled out those forms at the bank. Those assets, those will pass directly. The bank will just give the money to the person who's listed on the card that you filled out. But the rest of your items, those would be what's called subject to probate. And then the judge will decide when they can be given to the people you've named, or if you've died intestate, the judge will decide who they should be given to. This can lead to a lot of fighting, because usually what's passed down under a will is your tiara collection, your skateboard, your vintage guitar, the stuff that people really want and have an emotional connection to. So it can be a little dangerous. When you have a trust, you have to take the extra step after you've signed your trust of transferring all of your property into that trust. Usually your lawyer will do the work of transferring your real estate into a trust, and your lawyer really should be doing that because it's complicated and it has to be done exactly perfectly. Also, I think it's unkind for a lawyer to send their client down to the county clerk's office and to stand in line. When it comes to your bank accounts, most attorneys will want you to do that work on your own because it's important to understand how it works. And you may not see your estate planning lawyer again, but you might change banks and you might open a new account and you might do some online banking. And so it's really important to understand that every time you acquire a new asset, you really have to think about, do I need to own this as the trustee of my trust? If you don't transfer your assets to the trust, it might not be the worst thing in the world. Maybe, depending on the jurisdiction where you are located, your lawyer or the posthumous, your lawyer after death, whoever's managing this with your loved ones, could go to the court and say, you know, Your Honor, the house was supposed to be in the trust. There's language in the trust that says everything I own is supposed to be in there. And, you know, for one reason or another, it used to be in there, but we did a refi and it was taken out. Or look, it's listed as an asset of the trust, but for whatever reason, we don't know why the transfer never happened. It can be costly and it takes some time, but sometimes you lose. And then we're back to the probate court and maybe it's going to pass through intestacy, so we don't know who's going to get it. And so really to maintain control and to make sure that your beneficiaries are getting the best tax treatment and a surviving spouse is getting the best tax treatment, it's really important to transfer everything that you own into that trust, and to work with a lawyer who can help you do it if you get confused. Did I hit everything, Jennifer?
You did an excellent job. Thank you for that.
I love talking about this stuff. Estate planning is not sad and depressing. It's fun.
I threw a lot of questions at you and you answered them all. So I'm gonna segue back to some more landlord-tenant questions. Michael, this is a residential landlord-tenant question. It's an interesting fact scenario. I'm renting a room in my house to a person who left for COVID-19 treatment 7 days ago.
I actually, I think I may have answered this on the chat, but I can go through it real quick. Is it about the mother that lives in the house?
So the question, let me tell you my question, because they don't say mother, so I don't know. If you answered it on chat, great. I'm renting a room in my house to a person who left for COVID-19 treatment 7 days ago. I'm 60 years old and I don't want to die from exposure to this person. Can I ban them from my house from coming back? So no statement as to whether or not it's a mother or not.
It depends on the state, like we've been saying. It depends on if you have a lease. But even if you don't have a lease, if you've been accepting money from them and they're in possession, they have rights. They have rights as a tenant, whether they have a lease or not. In New York State especially, if you lock that person out, the courts are open for that and they have a right to be there. It's a really unfortunate situation to be in, and that's why everyone's having to quarantine and self-isolate, because they have a right to that space as well, and that's their home. And if they're not there, they're probably going to have to be with somebody else or homeless. So I would do your best to stay away from common areas, or at least maybe I would speak to the tenant and I would lay out, designate some areas. And maybe it would behoove you to hire someone to come in and clean the place every so often.
Great. And thank you very much for attending to the Q&As and the chats. I know everyone that's listening in really appreciates that because they can't talk to us in real time. And so they're trusting me to represent their questions well. So I appreciate that, Michael. Thank you. Here's my next question. Can a rent strike affect your credit history? Can a rent strike affect your ability to rent in the future? Should you only participate in a rent strike with an escrow account where you escrow the rent?
To be honest, I'm a tenant-friendly person, but I think the rent strike makes absolutely no sense. And you're going to owe the money. You're only causing more economic harm to your community. You're causing economic harm to your landlord. Maybe they were a good landlord. You know, you're gonna owe the money unless Governor Cuomo or the legislature decides otherwise. So if you have the money, pay the rent. If you think you're gonna, you know, kind of ride the coattails of other people's misfortune, probably not the best thing to do. If other people can't pay, they can't pay. Don't try to jump on the bandwagon. It would be my advice. Pay the rent.
Similar to Neil's advice, if you can pay your child support, pay your child support.
Yeah, I mean, if so, we go
rely on the fact that the courts are closed to not pay your child support. Pay
right.
it.
A rent strike is a protest, nothing more.
Right. Okay. So I feel really good. We're an hour and a half in. We have a half an hour left, and we're actually getting down to some factually specific questions. So I feel very good about what we've accomplished today, guys. I appreciate you so much. We've covered a lot of the general questions. With that said, Lou, I'm gonna ask you a fairly factually specific question here. It's a small business question. I'm a contractor, but I am unlicensed. I did a significant amount of work for contractor as a subcontractor on 3 projects, but it was just a handshake deal. Now he isn't paying me, and I'm worried that I can't pay my team if he doesn't pay. What are my next steps?
First step is to get a license. I hate to be glib about it, but you know, being unlicensed, unfortunately, is leverage from the other side to hold that over your head. So you should look into your state licensing laws. Secondly, you know, assuming you can get past that, you know, what could you do to get paid? You might consider, you know, making a demand for the amount of money that you're owed. You know, in certain instances and jurisdictions, there are statutes that protect people in your situation. You know, outside of the construction context. You know, for example, in New York City, there's something called, you know, freelance isn't free. The Freelance is a Free Act, which protects people from not paying, you know, essentially independent contractors. So you might want to consider if there's a similar statute in your jurisdiction. Now, the third thing is, you know, depending on how much money's owed, you know, what I often suggest is, and this is not just in response to your question, but any question, you know, a lot of clients come to me and say, well, I've tried and they're not responding. You know, my response to them is, well, you know, and I think someone hit on this before, you might want to look into whether this person has a history of being sued or not being sued, because if you find their name in a lot in the dockets, then you know that they're kind of going to skirt their obligations. But if you don't, you know, then you might consider sending them a demand letter which says, you know, I did this work, you owed me this amount of money. You know, if you don't pay me, we're gonna sue you. And you know, I've found that writing those letters on behalf of clients has helped. It's not to say that it works every time. You know, the other thing that you consider is, you know, how much money is at issue. You know, in New York, for example, if it's less than $5,000, you might consider filing a small claims matter. But you know, I've actually in court in New York, and I can tell you it's very difficult to collect on those types of things.
I would also add that, you know,
if someone owes you, go ahead, Bradley.
I'm sorry, maybe there was some kind of an audio issue. I was just going to say that in New York, you'd really be out of luck, but in other states where you're allowed to go and get the license and then bring your claim, that you'd want to throw on a mechanics lien if you could, and that very well might get you your resolution right there.
Mechanics lien is always the leverage. So that's why you get your license up front, so that you automatically get to protect yourself. And what Bradley and Lou are pointing out is that in some states, you can actually get licensed after you've started the job and still get a mechanics lien in place. All right, so I'm going to jump back to some landlord-tenant questions. Okay, Michael, residential question. How much time does my landlord have to present me with a written notice before raising my rent? I want to know if I receive a rent increase during this time, can I contest it?
It depends if your apartment is market rate or stabilized or any other type of protection like New York has. If it is, then they can only raise it a certain amount and they have to give it to you in a certain form, and it's got to be between, I think it's 90 and 180 days, so 3 to 6 months. Once you get that notice and once they can prove that you had gotten that notice, if you don't sign the lease and you decide to hold over and stay, you're going to owe whatever the notice was, as long as it was a proper calculation, whatever the notice said. If it's a market rate apartment, it's free for all. It's whatever you can negotiate with them. If they didn't give you much notice or they didn't give you enough, you think, you can absolutely just continue paying the old amount and stay in the apartment, knowing that down the road they may take you into court for the difference in small claims. But those notices are very, very tightly watched in New York City. So if there's any problem with it or any delay and it wasn't in the window, it's no good. So it really depends on when you got it, and it really depends on what kind of apartment you have and what city or state. I think you said it was New York.
They don't say.
Okay, well then that's my answer stands.
If it was in New York, there's lots of protection, and regardless of where the writer is from, there's probably statutory requirements in place as to what the notice has to comply with. So it's worth consulting with an attorney.
I used to practice foreclosures. I know Bowen knows this. The timeline of events is very, very important in notices.
Right. Okay.
Agreed.
Here's something. I gave 2 notices to my management company that I would not be renewing my lease, and that April 30th would be my last day. I asked them to send someone out with a mask to do a walkthrough to make sure I could get my deposit returned. They told me that because of the coronavirus, they would not be doing a walkthrough. What do I do to make sure I get my deposit back?
Get that in writing.
Get that they're not sending someone out to
get that in writing. Yeah, get that in writing. And then it's on them and you walk away. And, they'll have a certain amount of time where they have to return it, and they basically just gave up their right to walk through and inspect it. They waived it.
Got it. I like the answer to that question because we're telling the person who wrote in that they have rights. This is good. Okay, here's another one, and then we're gonna let Michael take a pause and we'll skip around. I am a tenant and I work from home in my apartment. I've had issues with my apartment, mold, and extreme noise from my upstairs neighbors during the day. And they told me verbally that I could pay less rent while they fixed the situation. I had to re-raise the issue, and now my landlord is threatening to take me to court for the back rent and has told me they want me to move out in 2 weeks. What can I do? Can they sue me for money after verbally telling me that I would get a rent break?
Well, one thing that's good about this is, people don't just start suddenly paying less rent, and landlords just don't start suddenly accepting less rent. So even if it was verbally, if you have a payment history where it shows you had a lease that was a term, and then in the middle of that term, the monthly amount changed and it happened several times, that's a good indicator that something happened. You know, I don't have to, it's like the circumstantial evidence thing. You know, I don't have to walk outside and feel the rain if I can, you know, look at the ground and see it's wet. You know, they're going to put two and two together. So if you can't get it in writing, or if you can't coax them to admit to it in a text message, I'd show up with some payment histories, and it's not going to add up to a judge.
Got it. All right, here's some more unemployment questions for Ifan. Here's a subcontractor or contractor with a question. I get most of my work from knocking on doors on construction jobs. I feel that I can't do that during COVID-19. What should I do? Can I get unemployment or other assistance? I'm worried about how long I can stay in business for my team.
Okay, yeah. So this is one of the circumstances in which the COVID relief, I think, addresses pretty squarely is, you know, the impact of your employment was directly from COVID. You can't walk door to door. So yes, I would apply for unemployment through your state unemployment service. Again, you might, you know, who knows how the state rubric is set up. Most states don't compensate independent contractors for unemployment, but there's a special rider within the federal COVID unemployment funding, which allows independent contractors unemployment relief. And again, at that $600 a week amount. I think that, is there another question in there?
Yeah, well, this is a second fact pattern, the second question, second writer, who I think you're on to the answer to his question as well. I formed an LLC, and I did lots of work for a major company consulting on manufacturing issues. With COVID-19, they have cut back and they no longer need my services, but they are by far my biggest client and practically my only source of income. Can I get unemployment? Am I eligible because I'm self-employed? If not, what can I do?
Exact same answer. You should apply. You will most likely meet the requirements for federal $600 a month payment. And again, most likely you won't satisfy whatever state you're in's requirement. I think most states don't pay independent contractors or LLCs, but you should apply. You should satisfy the federal.
Great. All right, here's a stimulus check / unemployment question. So I'm going to read it, and then whoever thinks they want to have a stab at it, raise your hand. I didn't get a stimulus check because I haven't filed my 2018 or my 2019 taxes yet. I'm told I'm not eligible for unemployment in my state, which they say is Florida. Doesn't my boss have to help pay me something since I was laid off?
May I address the second half of that?
Yes, please.
Question? And I think we did address the first half about whether you are eligible for $1,200, but the second half is I immediately asked people, who told you that? So who told you you were ineligible? So if you did look up the state standard, and you see you were ineligible based upon your analysis of unemployment, or you applied and they told you that, okay. But again, I get a lot of comments from potential clients and clients saying, well, no, my employer told me. Okay, but employers mostly try to comply and give their employees the best information, but they're not infallible, and sometimes they're intentionally trying to mislead you, right? So I would always ask, what's the source of your belief? That being said, there's still the federal application of unemployment that you can apply to. However, is your employer on the hook? No. There's no legal rubric that exists right now that places your employer on the hook for your missed wages, unless, of course, there is a violation of state or federal law, but that is a civil litigation matter that is outside of unemployment. Go talk to a lawyer if pertaining to the circumstances of why you believe your employer owes you wages, if it's outside of just work reduction due to COVID.
Got it. Okay, here is some more small business owner questions. How can I get a food vendor's permit in New York City right now? What precautions do I need to take to sell on the streets and reopen my food vendor's cart during COVID-19? Any of my New York attorneys have some thoughts on this?
Yeah, the only thing I'll say is that I'm not sure if your business would be considered an essential business. You might consider going to the NewYorkState.gov website and reading the governor's order on this, on what would qualify as an essential business. And again, if anyone knows, but to the extent you're allowed to do it, you're not violating the executive order by doing it. You know, I mean, using common sense, taking the necessary precautions to make sure that, you know, you're not transmitting a communicable disease, and being overly cautious is probably the best route.
Yes, good practical advice.
Also,
Brad?
this person is asking how to get the vendor license to begin with.
They said, yes, how can I get a food vendor's permit in New York City?
Well, the thing is, you need to get the license, which is not a problem, but then you need the vendor permit, and the vendor permits, there's only a very limited number of them. So typically people go through brokers, kind of like the way the medallions were. Now they probably just give you a medallion if you wanted one, but they're hard to get. It's, I was reading an article that they're like $18,000 or $20,000 to get it from someone who currently has the vendor permit. But once you go through a broker and you get one, then you just need to make sure you're considered essential and you can go out and do it.
Got it. Okay. Let's see. All right. Neil, here is a family law question. Maybe we answered this before, but I'm not sure. My ex-wife and I have a new agreement as to visitation. She wants to keep the agreement casual between the two of us. I want to file papers formalizing it. Can I even file these papers during COVID-19?
So as we've said before, it depends on the jurisdiction you're in, but I think essentially both federal and state courts across the US are all shut down except for emergency type hearings. A request of this nature wouldn't be considered emergency. I'm also a fan of working things out between parents before ever letting a court or a document guide how you're going to handle your life with your kids. I know that might be kind of counterintuitive coming from an attorney, but usually by the time you need us, it means that things broke down somewhere, between the parents, or for divorces, the same thing between the couples themselves. So if you can amicably keep an agreement just between you two on modification and it works out, do so. Again, remember though that anything that was previously awarded by the court is going to stand for the time being. So if there's any fallout from that or disagreements, then resort to a more formal approach.
Got it. Okay, Michael, some more residential landlord-tenant questions for you. I gave notice to my landlord in Brooklyn before April 1st that I could no longer afford to keep the apartment, and they put the apartment on the market. Is it safe legally for me to stop paying rent for May and beyond? Am I automatically released from my lease once the landlord signs a new lease?
Yes, once somebody signs a new lease and moves in, they've mitigated their damages and you don't owe the money. They can't double dip. However, if your lease has some type of breakage clause in there, a court will enforce that. If you've negotiated in your lease that if you vacate early, you owe them $400, regardless, it's in the contract. It's what's called liquidated damages. You've already negotiated this. You decided how much it's going to cost, and you put it in there. Now, you're not automatically, if the landlord says to you, you can leave. I saw another question like this in the chat. Let's say the landlord says, yeah, go ahead. I know you're supposed to be there through June, but if you vacate in April, I'll post the apartment April 11th, as long as you're out by the 10th. And you say, okay, and you leave. Just know that the landlord finding a suitable tenant is the precursor to you being relieved of your obligation. So they have to put a good faith effort into finding someone, but they may not find someone right now. People might not have money for moving costs. They may have to lower their standards for who they take. And now the landlord, turns 3 people away because they don't have as good income or credit scores. And then you go into the court and the judge is going to say, look, it's his apartment, her apartment, and they can rent it to whom they please. And if they're not financially stable, they don't have to rent it to get you off the hook. So I would be very careful, like before, get it in writing if possible, that you've been allowed to leave, but just know that you're kind of in the landlord's hands, and you're going to be, it's out of your hands, essentially, as to when your obligation is released.
Right. Okay. Patricia, here's a question. Is estate planning something that I can do on my own online with forms?
Oh, I mean, you could, but you shouldn't. You really shouldn't. Almost every state has its own statutory forms. So you can absolutely get an advanced healthcare directive from your local government. You can absolutely get a durable power of attorney from your local government. And most states also have a statutory will that you can also fill out on your own. And most of them come with really, really extensive instructions. The online pay $500, pay $700, and then you magically have a trust. I see a lot of those, and they are full of little things that will cause enormous problems later. They really lack a lot of clarity. A really good trust is usually at least 50 pages long, and every single paragraph relates back to a family that got in a big fight after somebody died. So if you go online and you create a trust that's about 12 pages long, you can imagine we're leaving out endless possibilities for people to fight. Also, those forms are generally not state specific. I'm here in California. We have Prop 13. And so we really have to think about how we transfer real estate in California. And we also are a community property state. And so you may very well create a document that gives away things that you don't own because it's a community property asset, and that just leads to problems. It's really much better to work with an attorney. There are usually estate planning is becoming more and more typical at legal services providers. So the same place that you would go for assistance with a family law issue or a landlord-tenant issue, those types of places are starting to realize that estate planning is not something that is the cherry on top of a financial plan, that it really is a first step towards adulting. And it's something that people from 18 years and older really need. So no matter what your price point is, you should be able to find an attorney who works only and exclusively doing estate planning, who can talk to you about your different family members and your different assets and help you create a plan that doesn't hurt anybody. And that is, even if taxes aren't an issue, you might think, oh, federal estate tax, it doesn't matter. There might be things in your jurisdiction like Prop 13 that affects real estate in California that could have a really bad impact on your plan. Don't do this alone. You will absolutely miss things. You don't know what to ask yourself.
Right. So it's the theme that's running throughout today. We are trying to be of service and give you some practical tips, but really, truly, it's worth it. It's worth your time. Talk to an attorney.
If you really do have to do it on your own, do it on your own with documents that were specifically created for you by your legislature. There's no reason to pay any of these people who are just trying to make a buck and are not lawyers. If you're going to DIY, I mean, go for it in DIY, but not through one of these ridiculous online services that they don't have malpractice insurance. If those documents are insufficient, there's no recourse for your family. There's no one for them to sue, and you've wasted money already. I just find them to be predatory, and I don't like that they exist.
All right, so go to if you really want to do it yourself, go to your state website, find the forms that are available there.
Yes.
All right, Bowen, here's a bankruptcy question for you. If my LLC files for bankruptcy due to COVID-19, will that impact my personal credit?
No, it will not. That's it.
Excellent. I'm sure that the person who wrote in is very happy with that very clear answer. That's great. Let me ask you another question. My car loan company sent a negative report to the credit bureaus for missed payments during the COVID-19 shelter-in-place orders. What can I do? Can they do that?
So this is part of the CARES Act that I've understood is that these lenders and creditors are not allowed to send negative credit information during this time, but that is only if you have called them to work out a particular agreement with them, whether that be forbearance or loan suspension payments. If you just didn't take the steps to call them and didn't pay, then they can report that negative information. So that's kind of where this all comes back to, is you need to speak to your lenders, and you need to speak to your creditors if you cannot make the payments right now, because everyone across the country is experiencing the same thing. So they have set plans for your situation.
So practically speaking, some advice that I hear coming out of today is if you find yourself in a situation where you can't pay your rent, or you can't pay your car loan, or you can't pay back a debt, the first step is to make a good faith effort to approach the lender directly, put it in writing, and see what programs are available to you. And that is possibly the best thing you can do to avail yourself of the protections that are there for you right now during the COVID-19 pandemic. Yep. All right. So we're coming down to the end now. I'm going to ask everybody one last question, and then I'm going to just take a few minutes to thank you, because I'm sure everyone really appreciates your time. I know I do. Michael, here's a question for you. I felt I was medically compromised at an apartment where I was living, and I wrote a notice to quit, and I gave 45 days notice of my intent to leave. One of the other signatories to the lease wants to stay in the apartment and continue renting for the remainder of the lease. The landlord wants to charge me with abandonment and pursue me to pay the remaining 8 months of the lease at the higher rate in the lease, and not work with the other tenant, which would require reducing the rent. I know that laws are prohibiting evictions right now, but does that also apply to not forcing someone to stay in an apartment if they are concerned about their health?
Yeah, we touched on this a bit earlier about, having roommates and being compromised. Off the top, nice work, sending the 40-day notice to quit, getting everything in writing, good job there. You covered your, rear end as far as initiating it goes. As far as the increase, whether it's timely, it's going to be jurisdictional. It's going to be based on what city or state you're in as to whether they allow them to do that. But again, the temperature of the courts is going to be such that if you were living in, one apartment with, or an apartment with one other person, you may not be as entitled to get out of that apartment without it being considered abandonment as if you had 3 roommates or 4 or something. So it's a sliding scale. Just be aware you may owe something. The landlord doesn't have to take that notice to quit. They could think I have a lease and they're going to owe me for the end of the term. And like we talked about before, that's going to come down to whether a court decides that this is a force majeure act of God that none of the parties could have considered. So it's uncertain. Just feel good that you did the right thing from here on out, and you're going to have to wait and see, unfortunately. But I sympathize with you there.
Got it. Okay, here is a small business owner question. So I throw it out and either Bradley or Lou can raise their hand and take a shot at it. How can I remove a false review from Facebook? I've done everything I can and I've reported it over 20 times and Facebook has done nothing. I worry that I'm losing money.
I'd be happy to give a response since I
Great.
see Lou hasn't unmuted yet. And then if Lou has another response, then of course I'll be interested to hear it. This is a tremendous problem. It's cruel and it's unfair to business owners that this kind of defamation is so well protected. The first thing that you're going to want to do is, of course, is try to work with Facebook. But, you know, if that's not possible, then I've seen people succeed in suing for defamation. And if they don't know who to sue, suing John Doe and basically just getting a ruling from the court that it was in fact defamation, and then sending it to the search engine or other service and asking them to remove it based on the fact that it's now proven to be defamatory in nature. A lot of people have gotten bad reviews and stuff off of Google that way. You know, I haven't checked in the last 6 months to see if it's still working because it's discretionary by Facebook or Amazon or Google or whatever. But a lot of times nowadays, it's the only thing that works. I don't know if Lou has some other understanding of how to deal with this.
No, it's a reality of doing business in the day and age that we live in, and it's amazing how it's the issue's only being exacerbated now when everyone's stuck in their house and a computer in front of them and they're angry. You know, these things are being popped out there more often. Yeah, I think a strong-handed approach in going back to the Facebooks and the Googles of the world and laying out the evidence, which disproves what the review says is not true by any means. The problem that you have is, as Bradley alluded to, is that, you know, statements of opinion are accepted under the First Amendment. So, depending on the way that the search engines or the companies approach this, you know, they're going to take a approach towards, if it's a 50-50 call, they're going to leave it up probably. That being said, like I was saying before, whether or not you try to do it on your own versus them getting a strongly worded letter from a lawyer, I think they're two different things and send two different messages. And I'm of the opinion that, to the extent Facebook is getting 1,000 inquiries from people like you in the same position, they're going to respond to the squeaky wheel first. And that squeaky wheel typically is a lawyer writing on their behalf. So if it's adversely affecting your business that much, you might want to consider talking to an experienced lawyer who writes a letter for you and see what they can do. And then if you have to, like Bradley said, move to get the judgment and then go from there.
Yes, Ifan.
I'm just kind of legally nerding out here that when I heard about the Elon Musk case and how the federal court came down with that one, which I think is relevant to the defamation case, I was really surprised and shocked. I think Bradley, what you said, it's amazing how much protection one gets on these sites and are able to say almost whatever they want to say. It's kind of shocking.
Yeah, the Musk thing was really interesting. But what's interesting about suing for defamation, and by the way, you also have to name the search engine as not a direct party, I forget what they call it, but like just formally including them in the lawsuit just so they have notice. But a lot of times, whoever you're suing, you don't even know who wrote it. It's anonymous. And so no one ever responds to it. You just end up getting some kind of a default judgment and then sending it over to the search engines. And a lot of the time, they just remove it now that you have some kind of a court order saying, yes, this is defamation. But yeah, the Musk thing was really something else.
Lou.
Yeah, I'll put this out there. I mean, imagine if you got to the point where you're asking a bunch of lawyers the question, that you probably considered this, but I think, from a non-legal perspective, responding to these types of comments in a positive way, laying out the facts. So if someone sees the review and they see your version of the story, which again, there's a balance. You can't be reacting at a point for point, so you look like they've got one on you and you're upset by it. But at the same time, putting the facts out there to the extent you can in the review and detailing an issue that was left out of the comment, then if someone's reading the comment above it and they see your comment, then they might put it in context. Because if you have 100 great Google reviews and there's one person out there who's obviously gone scorched earth on you, and you've responded positively to that, I think an informed consumer might make a better decision that way. But I do understand, given that I do use Google Ads and and other types of advertisements like that, having that negative review does move you down in the search. So, but it's a minor thing you might be doing short of litigation.
Yes, no, that's a really good practical tip. All right, I have one final question for Bowen and one final question for Patricia. So, and then we're going to wrap up our session today. Bowen, I closed on a house 3 weeks ago, and then I was just laid off due to the pandemic. My first payment is due this May, and it is a government-backed loan. Should I go into forbearance, and what happens if I do?
It's definitely going to depend on what they'll offer you. If like everyone else has said, if you can pay. If you can't, you got to call them and figure out what you can do, what forbearance program they will offer you. Sometimes they are offering complete suspension of payments. Sometimes they're offering forbearance agreements where you're paying them back at the end of the forbearance period. Those will generally catch up with you. I don't necessarily recommend those balloon payment forbearance programs. The other option would be to file a Chapter 13 bankruptcy. And we are expecting for those to be a giant influx of Chapter 13 bankruptcies at the end of this period. So probably coming up within the next 60 days, we're going to see a lot more of them for these people in this situation. If you can't pay it and you're not comfortable with the forbearance program, then I never want to recommend people to not pay their mortgage. But here's what happens is if you don't pay it for 2 to 3 months, they're going to send you a notice of foreclosure. In my state, in Georgia, they'll then run an advertisement in the newspaper for 4 consecutive weeks, and then they'll go to the courthouse steps and they'll auction the property off on the first Tuesday of the following month. All that takes time. All that was 60 days, what I just said. So it's not, I'm not saying to relax on it, but you have time and it's not an emergency at the moment. If it gets to the point where you're not comfortable with the forbearance or you didn't want to do the forbearance, so they wouldn't offer you forbearance, then the Chapter 13 bankruptcy would be what you would do, and you then pay back that arrearage over the next 60 months. And considering hopefully you get your job back and have steady income, you then pick up those payments directly and start paying your mortgage. I think Bradley had said earlier, Chapter 13s don't work unless you have new income, unless something has changed in your life where you have income coming back in. That's important to make note of. It's not an end-all remedy to your situation. And particularly with if it is a government-backed loan, I think we did say earlier, May 17th, which is coming up, they can't even send you a notice of foreclosure then, which tells me that they're not going to be able to send a 30-day notice until next week. So it's definitely hard to, consult and advise people on, what's the best situation to do. If you get to a foreclosure, go to a bankruptcy attorney and talk to them about your Chapter 13 options.
Great. Thank you, Bowen. All right, Patricia, my last question is for you. And it is, how often should you update your estate plan?
Yes. Yes. So many people get their estate plan done and I think they just put it under the bed. It's then after they pass away, it's covered in dust bunnies and out of date. So with my clients, I like to see them every 3 years. I think generally a good practice is every time you do your tax returns to go ahead and go to your estate planning binder, or however yours is, a stack of paper or whatever you have, your folder, and make sure that all of your assets are transferred to your trust if you have a trust, or go and look through your documents and make sure that if you named Hillary to be an agent for you, if she's supposed to do something on your behalf after you've passed away, is Hillary still around? Did she move to Fiji? Is she in jail? Where is Hillary? We don't know where she is. What if you have had additional children? They are 15 years younger than your other children? Does your estate plan properly provide for them? You always want to look at the people that you've named, and you want to make sure that your money, all of your assets are set up to pass smoothly to the people that you most want to take care of. So I would say absolutely, if you can, best practice, take a look every year. At the very least, make sure you meet with your lawyer. If you already have an estate plan, you have a lawyer every 3 years. And then you really want to, anytime there is a major life change, a death, a divorce, a birth, go back and look at your plan, because especially if you have been through something very emotional, if you've lost someone important, if you've been near someone through a catastrophic illness, you may have some very different ideas about what should happen to money or how you personally should be taken care of. And you may want to amend your documents. It's really more your life that steers that bus. But a good practice is to definitely look at it at least every 3 years.
All right, thank you so much. So to all of you who stayed with us through the last 2 hours, we hope we were of service and that this was useful and gave you some practical advice. We do all fervently believe, though, that it's worth talking to an attorney if you find yourself in a really difficult situation. You can always go to www.courtbuddy.com. We have attorneys. We also have resources there. We keep them up to date every day. So you can go there and you can find out answers to these kinds of topics, like what's going on with the payroll protection loan, for example, at CourtBuddy. And I just wanted to go around again one more time to say thank you personally to each of our panelists. They were great, and you would be doing yourself a huge favor by reaching out to any of them. So Bowen's practice is primarily focusing on bankruptcy and debt issues. He's in Georgia, and he is part of a firm, and you can reach out to them. Ifan is a part of a firm in San Diego that handles all aspects of employment law. Everything from workers' comp to harassment litigation to employment and unemployment claims. Ifan is a great resource for you. Neil is based in Southern California as well. He practices in San Diego and the Los Angeles area. He has a great family law practice. He also advises on criminal law matters and is very experienced DUI and DWI attorney. That is not something that we talked about today because we didn't get a lot of questions on that, but he is a specialist in that field, actually. Bradley is in New York, and he mostly serves founders of startups and small businesses as his clients. He can advise you on a whole host of things. We only focused on, what happens if you're a small business owner and you're worrying about your rent and you're not using your space, and what should you think about when you're thinking about breaking your rent? Well, Bradley covers so much more than that. He's a great resource for you guys. Lou is also in New York. He is also a small business attorney. He can help you with all kinds of commercial issues. Michael, if he can find time, and he is a guy with a big heart, so I'm sure he will find a way to find time. He is a great landlord-tenant lawyer in New York City. He himself is a tenant, and he fights for tenants. So he is a great resource for you. And Patricia, I've known her personally for a long time. She's here in San Francisco. She has great advice, and more than that, she looks at the whole family and she looks at the personal aspects involved when she's trying to make an estate plan for her clients. So you're not only dealing with a smart lawyer, you're dealing with a good person when you call Patricia. So keep her in mind. So again, I just wanted to say thank you to all of you for spending time with us on your Friday. For those of you who called in, I hope we gave you some really good practical, pragmatic tips. Please go to courtbuddy.com in the coming days and we'll get the transcript of today's session out to you. And to all of my attorney colleagues, you are my partners. I appreciate you so much. Thank you for helping me do some good today.
Thank you, Jennifer.
Thank you, Jennifer.
Thank you, Jennifer.
Thanks. Good afternoon, everybody.
All right.
Enjoyed it.
Bye.
Bye.
Bye, everybody.